Imagine this scenario. You've worked hard, you've, scraped together a down payment, and you finally buy a property. Maybe it's a villa, maybe it's a nice apartment. You sign the deed, you get the keys, and you have this moment where you just think, this is it. This is my castle. I am the king or queen of this domain.
It's that ultimate feeling of security, isn't it? The whole idea of private property.
Exactly. But then the honeymoon phase wears off.
Yeah.
You get an email or maybe circular slides under your door. It's from the neighborhood committee. And suddenly you realize that your castle, it actually comes with a board of directors.
Right.
You aren't just a homeowner. You're a unit in a spreadsheet.
Mm-hmm.
And this committee has decided that they don't like how you're using your house.
Mm.
They don't like who you're renting to. They want copies of your private financial contracts. And get this, if you hire a plumber to fix your sink, that plumber isn't allowed to use a toilet anywhere on the premises.
It sounds like fiction, honestly. It really does. It sounds like some kind of dystopian novel about bureaucracy gone wrong. But for millions of people living in gated communities or managed societies, this is just Tuesday.
It is.
The tension between I own this property and we manage this community is, well, it's arguably one of the most significant legal battlegrounds in modern urban living.
And we are going to get right into the thick of that battleground today. We are doing a deep dive into a very specific real-world case study. We are not dealing with hypotheticals here. We have the official minutes of the management committee meeting from the Vasanth Vihar Residents Welfare Association, or VVRWA, held just recently on January 17th, 2026.
And we aren't just going to read meeting minutes, because let's be honest, that is a surefire cure for insomnia.
Right.
To make sense of this, we are pairing those minutes with two really rigorous legal analyses by a legal expert named Chandra Nath. One is titled Critical Review Comments with Liberal Nuances, and the other is the final analysis from a homeowner rights perspective.
These documents are incredible. They really are. They take these dry administrative decisions, agenda item 1, approved, and they just crack them open to reveal the massive constitutional questions hiding inside.
Oh, absolutely.
We're talking about property rights, privacy law, even basic human rights.
It's a fascinating contrast. You see the committee acting with what looks like absolute authority, and then you see the legal analysis coming in and saying, wait a minute, you can't actually do that.
So our mission today is to unpack that tension. Whether you own a home, rent one, or maybe you even sit on an RWA board yourself, this is going to be a masterclass in what a residents' welfare association can legally do versus where they are likely breaking the law.
The stakes are high.
They are. We're asking, is your home your private property, or is it just a subsidiary of the association? Because looking at these VVIRY documents, specifically the meeting from January 17th, it feels like the committee believes they have the power to regulate the inside of your home, not just the road outside.
Let's look at the evidence.
All right, let's jump straight into the deep end. The first thing that jumps out from these minutes, and honestly it's the most shocking, is the no multi-tenancy diktat. This is agenda item number 1.
This is a huge issue, and it really sets the tone for everything else that follows.
So the minutes state that the management committee ratified a decision to prohibit multi-tenancy entirely. But they didn't stop there. They added a condition for people who already have these arrangements. The rule says existing multi-tenancy arrangements cannot continue beyond the current lease or 1 year, whichever is earlier.
Let's just pause and sit with that for a second. 1 year.
1 year.
They have effectively put an expiration date on a specific type of residency in your own private property. It's quite breathtaking.
My jaw hit the floor when I read that. I mean, let's say I own a 4-bedroom villa. It's my house. I pay the mortgage. If I want to rent it out to, say, 3 young professionals, maybe engineers or doctors, who want to share the rent, that's multi-tenancy.
A very common arrangement.
Right. Can a committee really just vote and say, no, you have 1 year to kick them out?
Well, if you ask the committee, clearly they think the answer is yes. They believe that because they pass a resolution, it's now the law of the land for their community. But if you look at the final analysis document by Chandra Nath, the legal answer is a resounding no.
Okay, so why? What's the legal shield for the homeowner here?
It comes down to a fundamental piece of legislation in India. It's called the Transfer of Property Act, and specifically Section 108J.
Section 108J.
Yes. It essentially guarantees a lessee, that's the tenant, the right to transfer their interest in the property. This implies that the right to sublet or share the space is inherent to the tenant unless the contract between the owner and the tenant forbids it.
Okay, so the contract is between me, the owner, and my tenants. The RWA isn't a party to that contract.
Precisely. That is the absolute key.
Hmm.
The RWA is a third party. They are, at the end of the day, a service provider.
Right.
Their job is to manage the common areas, the roads, the parks, the clubhouse, the garbage collection. They do not own the inside of your unit. By imposing this ban and this one-year cap, they are trying to insert themselves into a private contract between two other adults.
And the analysis points out another huge problem with this: retroactivity.
Yes, this is a massive legal no-no. It's called retroactive application. Imagine you signed a valid legal 3-year lease with a group of tenants in December.
Yeah.
Then in January, the RWA meets and says, we just decided we don't like that. You have to stop in 1 year.
You can't just change the rules of the game after the game has already started.
Exactly. You cannot use a new resolution to invalidate a contract that was perfectly legal and valid when it was signed. If that went to court, the RWA would almost certainly lose because they are trying to override a statutory right with a simple committee vote.
The documents also mention the Constitution, Article 300A. I mean, that feels incredibly heavy for a neighborhood dispute.
It feels heavy, but it's actually completely appropriate. Article 300A is the right to property. It says no person shall be deprived of his property save by authority of law.
Authority of law.
Now, authority of law is a very specific phrase. It means a law passed by Parliament or a state assembly. It does not mean a resolution passed by a group of neighbors on a Sunday morning.
So the RWA, which is registered under the Karnataka Societies Registration Act, has the authority to manage the society, but not to act like a mini parliament.
Correct. The Societies Registration Act allows them to maintain the campus. It doesn't give them police powers to regulate the private lives or the business decisions of the owners.
But let me play devil's advocate here for a moment, because
Okay.
I know there are listeners thinking, well, I don't want a hostel running next door to me with 20 people in it.
A valid concern.
The Comments with Liberal Nuances document does suggest that RWAs aren't totally powerless. It's not the Wild West, right?
That's a really crucial distinction, and I'm glad you brought it up. The nuanced analysis points out that the homeowner rights perspective can sometimes be a bit too absolutist. It's not that RWAs have zero power. They do. But their power to restrict your property rights is valid only under very, very specific conditions.
And what are those conditions?
Well, the first one is if the restriction was in the original registered sale deed. This is what lawyers call a covenant running with the land.
Ah, so it's in the DNA of the property itself.
Exactly. If you signed a deed that explicitly said no multi-tenancy when you bought the house, then you are bound by it. You agreed to that condition from day one.
Which is pretty rare for a standard villa or apartment, I'd imagine, unless it's a retirement community or something very specific.
Very rare. The second condition, and this is the big one, is if it's a statutory safety issue. This is where the RWA has real teeth.
Like fire safety.
Precisely. If you pack 20 people into a 3-bedroom apartment, that's not just multi-tenancy, that's a fire hazard. It violates the Fire Force Act. It violates municipal overcrowding norms.
I see.
In that case, the RWA can step in. But notice the difference. They aren't enforcing their own preference, they are enforcing the law of the land.
Right. They are acting as deputies for the fire department, essentially. Or, what about structural safety?
Yes, structural load. In a high-rise, you can't have unlimited weight. You can't turn an apartment into a warehouse for, I don't know, heavy machinery. That's a valid restriction because it affects the safety of the entire building.
But in this VVRWA case, looking at the minutes for Agenda 1, they don't mention fire safety or structural loads, do they?
No, they don't. And that's where they failed legally. They set an arbitrary timeline 1 year without citing any safety norms, without any evidence. They just decided they didn't like the concept of multi-tenancy.
And practically speaking, that 1-year rule is a nightmare. If I have a lease that runs for 2 more years and the RWA forces me to kick the tenants out in 1 year, who pays the penalty for breaking the lease?
You do. The owner does. The RWA takes on zero financial risk, but they are forcing you to incur a liability. It's a classic case of power without responsibility.
The source text also highlights a procedural failure. Even if they wanted to ban this, they went about it the wrong way.
Right. If you want to change a fundamental right related to property, you usually need to amend the society's bylaws.
Okay.
That requires a general body meeting, not just a committee meeting. It usually needs a 2/3 majority vote of all members, and this is the part everyone forgets. You have to register that amendment with the Registrar of Societies. You can't just have a committee meeting say ratified and expect it to hold up in court.
So the big takeaway for this first part is an RWA resolution simply cannot override a statute like the Transfer of Property Act.
And remember this phrase from the analysis, it's a powerful one. Majority vote doesn't cure illegality. Just because 99 people vote to strip the rights of the 100th person, that doesn't make it legal. That is the very definition of the tyranny of the majority, and the Constitution is there specifically to stop that.
It's fascinating how quickly community management can slip into community policing.
It's a very slippery slope.
And that mindset seems to bleed into everything else. If the no multi-tenancy rule was about control, this next segment feels like it's about, well, punishment. Or maybe just profit. Let's talk about the tenant penalty.
This is Agenda Item 9 in the minutes, the revised monthly maintenance charges.
Let's break down the financials here, because money talks. Effective April 4th, 2026, RWA is implementing a new pricing structure. If you are an owner living in your villa, you pay Rs. $4,995 per month. But if that same villa is tenant-occupied, the fee jumps to Rs. $5,245.
So that's a direct surcharge of Rs. $250 per month simply for the crime of having a tenant.
And it doesn't stop there. There is a move-in fee of Rs. $2,500, which is non-refundable, and a refundable security deposit of Rs. $7,500.
The comments with nuances analysis really digs into this Rs. $250 surcharge. The fundamental legal question here is, why? What is the justification for it? Why does a tenant cost Rs. $250 more per month than an owner?
Does the tenant breathe more air? Do they walk on the pavement more heavily? Do they use more streetlights? I mean, what is it?
That's exactly the point. The analysis calls this a lack of a cost study. Viva RWA hasn't proven, at least not in these minutes, that tenants generate Rs. $250 worth of extra cost. In the absence of that proof, this fee looks punitive. It looks discriminatory. It creates a second-class citizen status for renters.
The legal term used in the sources is ownership parity. Can you unpack that for us?
Sure. Ownership parity implies that two identical units should be treated equally in terms of common area maintenance, regardless of who is sleeping inside.
Makes sense.
Think about it. You have two identical villas side by side, same square footage, same share of the common area. One has the owner living in it, the other has a tenant. The wear and tear on the road, the security guard at the gate, the landscaping, it is arguably the same for both houses. So why is one paying more?
Unless the RWA can document that tenants statistically consume more resources.
Right. And that's a high bar. If they could produce data proving that, on average, tenant-occupied units call security 3 times more often or have 50% more visitors, which increases gate management costs, maybe they'd have a case.
But they don't have that.
But without that data, this differentiation is discriminatory. It's based on a prejudice, not on evidence.
But wait, the analysis does compare this to a valid differential. They mentioned Pocket 3 versus the villas. This was interesting because it shows the law isn't just about saying no to everything the RWA does.
Yes, and I love this part of the analysis because it shows the logic of the law so clearly. Pocket 3 consists of apartments, multi-story buildings. The villas are independent structures. The minutes show that Pocket 3 residents pay higher maintenance Rs, $5,230 compared to Rs, $4,995 for owner-occupied villas.
And the source says this is legally defensible, so why is that fair? But the tenant charge isn't.
Because of actual physical infrastructure. The minutes list specific costs for Pocket 3 that the villas don't have.
Like what?
They have lifts. Lifts need maintenance. They have generators specifically for those lifts, which use fuel. They have specialized annual maintenance contracts, AMCs for high-rise equipment.
Okay, that makes perfect sense. I live in a villa. I don't use the lift in Pocket 3, so I shouldn't have to pay for its upkeep.
Exactly. That is a principle called user pays or cost recovery. Charging Pocket 3 residents more is fair because they are demonstrably consuming more services. Charging tenants more without similar proof of extra cost is just a penalty. It's arbitrary.
Now, what about that move-in fee? $2,500, non-refundable. That feels steep just to say, hello, I live here now.
The legal review is quite critical here. It calls it an unlawful exaction if it's not cost justified.
Unlawful exaction.
It basically means the RWA is using the tenant as a revenue stream, as a profit center. However, the nuanced analysis does offer a lifeline to the RWA here. It says administrative charges are valid if they cover actual work performed.
What kind of work would that be?
Well, think about the logistics of someone new moving in. You might need to issue RFID tags for their car. That's a real cost. You might need to process a background verification through a third-party service. You need to update the gate management software. Apps like Apna Complex or MyGate. Someone has to sit at a computer and do that work.
So if the RWA spent time and materials on this, they can charge for it.
Correct. The analysis even provides a hypothetical breakdown. It estimates legitimate costs might be around Rs 1,200 to maybe Rs 2,100 for materials and man hours. If RWA could show a spreadsheet saying, look, onboarding a new tenant costs us exactly Rs 2,450 in verifiable expenses, they'd be legally safe.
But they didn't do that.
No, the minutes are silent on the breakdown. They just slapped a round number, Rs 2,500, on the table. And that leaves them open to what the analysis calls high litigation risk.
Because it just looks like they're making money.
It looks like revenue generation. It looks like taxation without representation. You're taxing the transient population, the renters, because they usually can't vote in the AGM, so they have no voice to complain.
And effectively, by taxing the tenant, you're taxing the owner. If I have to tell my prospective tenant, by the way, you have to pay all these extra fees just to exist here, that makes my property less attractive on the market.
Exactly. You are directly interfering with the owner's rental yield and the marketability of their private property.
Speaking of interference, let's talk about privacy. Because Agenda 10 isn't just asking for money, it's asking for your papers. The policy requires members to notify the secretary 7 days prior to a move, and this is the big one, submit a scanned copy of the rental agreement.
This creates a massive privacy problem. I mean, just think about what is actually in a standard rental agreement.
Everything. The rent amount, the security deposit, sometimes bank details, CAN numbers, maybe even personal clauses about who is allowed to visit or if pets are allowed or what furniture is included. It's a very detailed document.
Exactly. Why does the RWA need to know how much rent you're charging? That is a private financial transaction between you and your tenant. Why do they need your bank account number? The expert view in our sources states this very clearly. The RWA is not a party to the contract. Demanding the full contract is a classic example of overreach.
But surely they need to know who is living there for security purposes.
And that is the valid side of the coin. We can't ignore safety. The sources mention the post-2611 security environment.
Right.
Police orders in many cities do require tenant verification. The RWA has a legitimate need and, frankly, a duty to know who is on the premises. Names, contact info, emergency contacts for common area security.
So how do you strike that balance? How do you satisfy the need for security without completely violating privacy?
The solution proposed in the critical review is actually very elegant and simple. Don't demand the contract, use a simple tenant details form, have the owner fill it out, declare the lease period and the names of the residents. If the RWA is really paranoid and needs to verify that a lease actually exists, let the manager see the agreement to verify it visually, hand it right back, and not store a copy.
Because storing it creates a data protection risk, right?
A huge risk.
Right.
We have the Digital Personal Data Protection Act now. RWAs are generally run by volunteers. They aren't data security experts. If that rental agreement leaks, if the secretary tells his neighbor over tea, hey, did you know Unit 504 is charging 80 grand a month? That is a violation of privacy. Holding on to sensitive financial contracts is a liability time bomb for the association.
It seems like VVRWA is trying to be the landlord, the police, and the bank all at once. And that attitude doesn't just affect the residents, it seems to trickle down to the people who work there. This brings us to segment 4, which I like to call petty authoritarianism.
You're referring to the toilet ban and the silence rule.
Yes. Agenda 3. The minutes say, and I'm quoting here, the toilets in the guard post are for RWA staff only. They explicitly state that laborers, courier personnel, and outsiders are banned because, and this is the reason given, guards and housekeeping don't want to clean up after them.
This is where we move from legal technicalities to just basic human dignity.
It's honestly shocking. Imagine a plumber comes to fix a leak in your villa. He's there for 8 hours. He's working hard, sweating. Where's he supposed to go to the bathroom?
The minutes imply he has to go elsewhere, outside the main gate. This isn't just rude. The analysis points out it could be a violation of labor laws.
Also,
Homeowners, as the employers of these workers for the day, have a legal obligation to provide basic amenities, including access to sanitation. By banning them from the community toilets, the RWA is practically forcing homeowners to violate the law.
and the excuse is maintenance. They just don't want to clean it.
Which is an operational failure, not a security issue. If the toilet gets dirty, you schedule more cleaning. You assign duties properly. You don't ban an entire class of people from using the bathroom. It's a maintenance issue disguised as a security or access issue to mask what is essentially a class-based exclusion. It's saying you are not one of us, so you don't get basic facilities.
It really feels like they are treating outsiders, who are actually essential service providers, as some kind of contaminants. And speaking of treating people like children, let's look at Agenda 5, the silent work bureaucracy.
This one is genuinely puzzling. The rule says silent work on Sundays and holidays, like curing concrete or cleaning, now requires approval from the pocket secretary 24 hours in advance.
Okay, for anyone who doesn't know, curing concrete is literally just sprinkling water on a wall so the cement sets properly.
It's silent.
It makes zero noise. Why do I need to ask a pocket secretary for permission to sprinkle water on my own wall on a Sunday?
This is micromanagement defined. The legal analysis distinguishes this very sharply from noise restrictions. Look, banning drilling or hammering between 2 p.m. and 4 p.m., that's valid. Statutory noise norms exist, and everyone deserves a quiet afternoon on Sunday. We all agree on that.
Of course.
But regulating non-disruptive activity inside your own private property, that's just overreach.
It's absurd. It's like, hello, Mr. Secretary, I would like to wipe my windows tomorrow. Is that okay?
And what if the secretary's busy? What if he's out of town? Or what if he just doesn't like you? It creates a permission culture where your rights are replaced by favors. It violates the legal concept of the quiet enjoyment of your property. If I am not disturbing anyone else, the RWA has no business knowing or controlling what I am doing inside my own house.
It really paints a picture of a committee that wants to know everything and control everything. But what happens when things go wrong? When the RWA itself makes a mistake? Segment 5 covers a story that is honestly a nightmare for any homebuyer. The case of the bounce check and the no-due certificate.
Agenda 6.6. This is a cautionary tale for everyone listening today.
So let's lay out the story from the minutes. A previous owner, Mr. Sharma, sold his flat. Before leaving, he issued a check for Rs. $10,000 for maintenance dues. The RWA office accepted it and then issued a no-dues certificate, an NDC, to him.
And the NDC is the golden ticket in real estate transactions. It tells the new buyer, this property is clean, there is no debt attached to it.
Exactly. So relying on that certificate, the new owners, Mrs. Bhavna and Wing Commander Himanshu, bought the flat. They moved in. But then the check from Mr. Sharma bounced. The RWA realizes their mistake. So what do? They put the arrears on the new owner's account.
Which is legally incredibly shaky. There's a legal principle called estoppel that applies here.
Estoppel.
Essentially, it means the RWA issued a certificate saying no dues. The buyer relied on that representation to close the deal. The RWA cannot turn around later and say, oops, we messed up. Actually, you owe us money. It was their administrative failure.
And now the RWA is chasing Mr. Sharma, who is apparently in Natal, and not replying to their emails.
This highlights the need for internal accountability. Why did they issue the certificate before the check cleared? That's a basic process failure. But there's a broader risk here, too. The minutes also authorize the hiring of legal counsel to go after chronic defaulters.
Which sounds reasonable on the surface. You want people to pay their dues.
It does, until you combine it with the illegal fees we discussed earlier. Imagine you refuse to pay that illegal Rs. 250 tenant surcharge on principal.
Okay.
The RWA marks you as a defaulter. Then they use this broad authorization to hire lawyers, using your own maintenance money, to sue you for a fee that was illegal in the first place.
That's terrifying. I'm funding the lawsuit against myself.
Essentially, yes. The analysis warns that without strict oversight and caps on legal spending, this legal recovery power can be weaponized. The RWA could spend Rs. 50,000 in legal fees to recover Rs. 2,000 just to make a point, and the entire community pays for that loss.
It's a dangerous loop. But look, I promised at the beginning that this deep dive wasn't just about bashing the RWA. There's actually an example of good governance in these minutes, right?
There is, and it's so important to highlight it because it shows that when RWAs stick to their lane managing common infrastructure, they can do a fantastic job. We're talking about the Pocket 3 deep dive in Segment 6.
We mentioned earlier that Pocket 3 pays more maintenance and that it's legitimate. But the minutes go into detail about how they are managing a massive painting project for these apartment buildings.
Yes, Agenda 7 details the formation of a project management group, or PMG.
They appointed a presiding officer, a Colonel Sativir Yadav, and a team of members. And they have a specific charter of duties.
This is textbook good governance. Instead of the general committee trying to micromanage a huge, complex contract with burger paints, they delegated it to a focused group with specific responsibilities. The minutes show they are tracking physical progress, financial progress, safety measures, and quality standards. It's professional.
And they are transparent about the costs. We have the invoices in the source material. The sink fund for Pocket 3 is Rs. 300, which is distinct from the Villa's Rs. 410. They have specific line items for sinking garages repair, and pipeline replacement.
Exactly. This is evidence-based charging. They identified a specific problem painting, plumbing, sinking garages in a specific area, which is Pocket 3. They created a specific oversight body, the P&J, and they charged the specific people who benefit from it. No one is complaining about this because it's transparent, it's fair, and it's tied to actual asset management.
It contrasts so sharply with the tenant surcharge. One is, here is the invoice for the paint on your building's wall. The other is, here is a random fee because we don't like that you have tenants.
That's the perfect summary. One is management, the other is moral policing or, revenue padding.
So what does this all mean for us, for the listener? We've gone through the minutes, the legal analysis, the good, the bad, and the ugly.
If we synthesize all of this, the VRR minutes and Chandra Nath's critique, we come away with a very clear picture of the mixed bag of community governance.
On one hand, you have the PMGs, the quiet hours, the legitimate management of common assets. On the other, the retroactive bans, the arbitrary fees, the data hoarding.
The sources essentially boil down to 5 principles for lawful governance that every listener should know. If you are reading your own RWA minutes, and you really should be, look for these principles.
Let's run through them. Principle number 1.
Prospectivity. Rules change for the future, not the past. You cannot ban something today and then punish someone for doing it yesterday. If you have a valid lease, you get to keep your lease.
Simple enough. Principle number 2.
Evidence-based. Charges need cost studies. If you want to charge different people different amounts, you have to show the math. Don't assume, prove.
Number 3.
Procedural legitimacy. You cannot vote away statutory rights. A general body meeting resolution is not above the law of the land. Section 108J of the Transfer of Property Act beats a Sunday morning vote every single time.
That's a big one. Principle number 4.
Data minimalism. Collect only what you absolutely need for security. Don't hoard rental agreements or private financial data just because you're curious or, frankly, power hungry. Verify and return.
And finally, number 5.
Separation. Manage the common areas. Do not regulate the private lives inside the homes.
That last one really is the golden rule, isn't it? Manage the road, not the bedroom.
Ideally, yes. That's the boundary.
It leaves us with a final, provocative thought to end on. We often hear people say, but the majority voted for it. Or, it's for the good of the society.
And the final thought is this. If an RWA passes a rule that violates the Constitution, like your right to property under Article 300A, does it matter if 99% of the residents voted for it? The answer legally is a clear no. Fundamental rights are not up for a popularity vote. That is the essential difference between a democracy and a mob.
That is definitely something to chew on. So, call to action time for our listeners. Dig up your latest RWA meeting minutes. Read them. Are you paying a tenant penalty? Are the people who deliver your packages allowed to use the toilet? Is your committee acting like a manager or a monarch?
It's your home. It's your castle. It's worth knowing the rules.
Thanks for joining us on this deep dive, keeping you informed, one deep dive at a time. We'll see you in the next one.